Hello everyone, let's continue the video. We were basically discussing AIB 11 previous year question paper and we have already done up till question number 35 and we will continue further. So we have already done, this is part second by the way, so we have already done up till question number 35 and I'm repeating the 35 question number 35 once again. The case Krishna Gopal versus State of Madhya Pradesh relates to option we have water pollution, option B air and water pollution, option C noise and air pollution, option D water and noise pollution. Its right option is option C, which is noise and air pollution. So Krishna Gopal versus State of MP relates to or relates with noise and air pollution. Question number 36. What is the punishment for advocates if the established finding of the Bar Council is misappropriation? What is the punishment for advocates if the establishing finding of the Bar Council is misappropriation? We have the option A impose fine, option B name of the advocate will be struck off from the rolls, option C suspension from practice, option D all of the above. Its right option is option D, which is all of the above. So the Bar Council basically impose a fine or can struck off the name from the rolls or suspend from practicing. Okay. Question number 37. On being aggrieved by the order of State Bar Council, on being aggrieved by the order of State Bar Council, one can appeal to option A, High Court, option B, Supreme Court, option D, option C, Bar Council of India, option D, Indian Law Commission. Its right option is option C, which is Bar Council of India. Question number 38. Which section of Advocates Act provide punishment for misconduct of advocates? We have section 29, 35, 37, or all of the above. Its right option is option B, which is section 35. So section 35 of Advocates Act provides punishment for misconduct of advocates. Section 35. Question number 39. Section 24 of Advocate Act deals with Section 24 of Advocate Act deals with option A, qualification of advocates who should be enrolled in the bar, option B, qualification to become the Advocate General, option C, qualification to become the Solicitor General of India, option D, both B and C. Its right option is option A, which is qualification of advocates who should be enrolled in the bar. Section 24 of Advocates Act deals with qualification of advocates who should be enrolled in the bar. 35 deal with misconduct, act of misconduct, and 24 deals with qualification of advocates who should be enrolled in the bar. Question number 40. Under the Compensation Act, under the Workmen's Compensation Act, which is helpful in deciding the extent of injury for compensation, which is helpful, which is helpful in deciding the extent of injury for compensation. Option A, insurance certificate. Option B, medical examination. Option C, medical certificate. Option D, both B and C. Its right option is option D, which is both B and C. So medical examination as well as medical certificate. Under the Workmen Compensation Act, which is helpful in deciding the extent of injury for compensation, medical examination as well as medical certificate. Question number 41. Section 23 of Workmen Compensation Act 1923 says that the commissioner shall have the power of option A court, option B a tribunal, option C a quasi judicial form, option D all of the above. Its right option is option A, which is a court. Okay, so under section in section 23 of Workmen Compensation Act, which says that the commissioner shall have the power of a court. Question number 42. The objective of the Industrial Dispute Act 1947 is option A, industrial peace and economic justice, option B, to create harmonious relation between employer and employee, option C, to prevent illegal strike or lockout, etc., option D, all of the above. Its right option is option D, all of the above. So the objective of Industrial Dispute Act 1947 is to make industrial peace, create industrial peace and economic justice, to create harmonious relation between employer and employee, and to prevent illegal strike or lockout, etc. Question number 43. Section 2Q of Industrial Dispute Act 1947 provides the definition of option A, lockout, option B, layoff, option C, strike, option D, hartal. Its right option is option C, which is strike. So the definition of a strike has been mentioned in section 2Q of Industrial Dispute Act 1947. The Land Acquisition, next question is, the Land Acquisition Act came into force from the option we have 1st March 1955 or 1986 or 1994 or 1894. Its right option is option D, which is 1st March 1894. 1st March 1894, the Land Acquisition Act came into force. Question number 45. Under the Land Acquisition Act, the arable land means basically option we have useful for residential purpose, useful for commercial purpose, useful for cultivation, useful for industrial purpose. Its right option is option C, which is useful for cultivation. Under the Land Acquisition Act, the arable land means useful for the land which is useful for cultivation. Question number 46. Which one is not a fundamental right? Which one is not a fundamental right? Option we have right to freedom of assembly, option B right to property, option C right to equality, or option D right to freedom of speech and expression. Which one is not a fundamental right? So its right answer is option B. So right to property is not the fundamental right. Question number 47. In Manika Gandhi case, it was observed that option A, confiscation of passport was correct. Confiscation of passport was correct. Option B, right to go abroad is not within the meaning of Article 21. Option C, right to go abroad is within the ambit of Article 19, Clause 1, Subclause A, but the confiscation of passport is not in accordance to the law. Option D, none of the above. Its right option is option C, which is basically in Manika Gandhi case, it was observed that right to go abroad is within the ambit of Article 19, Clause 1, Subclause A, but the confiscation of passport is not in accordance to the law. Question number 48. Reasonable restrictions can be imposed on the right of free movement. Question number 48. Reasonable restrictions can be imposed on the right of free movement. On the right of free movement. Option A, in the interest of general public. Option B, in the interest of political leaders. Option C, in the interest of women's safety. Option D, all of the above. Its right option is option A, which is in the interest of general public. So reasonable restrictions can be imposed on the right of free movement in the interest of general public. Reasonable restrictions can be imposed on the right of free movement in the interest of general public. Question number 49. Which one of the following can claim Article 19 of the Constitution? Option A, company. Option B, a corporation. Option C, only citizens. Option D, citizens and aliens. Its right option is option C, which is only citizens. So basically only citizens can claim Article 19 of Constitution. The benefit of Article 19. Next question 50. Clause 3 of Article 20 I of Indian Constitution says that no accused person shall be compelled to be option A, an accused, option B, a witness, option C, a witness against himself, option D, hostile witness. Its right option is option C, which is a witness against himself. So clause 3 of Article 20 I of Indian Constitution says that no accused person shall be compelled to be a witness against himself. Question number 51. Indira Sahani versus Union of India is popularly known as option A, judges transfer case, option B, illegal detention case, option C, Mandal Commission case, option D, constitutional case. Its right option is option C, which is Mandal Commission case. So Indira Sahani versus Union of India is popularly known as Mandal Commission case. Question number 52. Due to the outcome of this case, slum dwellers were benefited. Option A. NK NK Chanda versus the state of Haryana. Option B. Olga Telis or Telis versus Bombay Municipal Corporation. Option C. PV Narasimha Rao versus Union of India. Option D. Ratlam Municipal Council versus Vardhi Chand. Its right option is option B, which is Olga Telis versus Bombay Municipal Corporation. Question number 53. A public interest litigation can be filed under option A, Article 226 of Constitution and 32 of the Constitution. Option B, under Section 133 of Criminal Procedure Code. Option C, A and B both. Option D, none of the above. Its right option is option C, which is A and B both. So a public interest litigation can be filed under Article 226 or Article 32, under Article 226 or Article 32 or under Section 133 of Criminal Procedure Code. Question number 54. Supreme Court in SP Gupta versus Union of India. Supreme Court in SP Gupta versus Union of India AIR 1982 decided. Question number 54. Supreme Court in SP Gupta versus Union of India AIR 1982 SC 149 decided on option A, free legal aid, option B, bonded laborers, option C, judges transfer, option D, illegal detention. Its right option is option C, which is judges transfer. So the Supreme Court in SP Gupta versus Union of India decided on the matter related with judges transfer. Question number 55. Supreme Court in a PIL known as Kamal Nath case, it evolved option A, basic future and basic structure doctrine. Option B, public trust doctrine. Option C, separation of power doctrine. Option D, public interest doctrine. Its right option is option B, which is public trust doctrine. Public public trust doctrine. Supreme Court in a PIL known as Kamal Nath case evolved on public trust doctrine. Question number 56. Visakha versus State of Rajasthan case is related to option A. Harassment at workplace. Option B, protection of civil rights. Option C, uniform civil code. Option D, none of the above. Its right option is option A, which is sexual harassment at workplace. So the Visakha versus State of Rajasthan case is related to sexual harassment at workplace. Question number 57. Court's power to award compensation is provided in Specific Relief Act. Question number 57. Court's power to award compensation is provided in Specific Relief Act. Court's power to award compensation. Court's power to award compensation is provided in Specific Relief Act. Court's power to award compensation. To award compensation is provided in Specific Relief Act. Option A, under Section 20, under Section 21. Option C, both A and B. Option D, none of the above. Its right option is option B, which is under Section 21. So the court's power to award compensation is provided in Specific Relief Act under Section 21. Question number 58. Proving of handwriting is provided in Indian Evidence Act. Proving of handwriting is provided in Indian Evidence Act. Option A, by the opinion of experts. Option B, by the evidence of a person who is acquainted with the handwriting. Option C, after police verification. Option D, both A and B. Its right option is option D, which is both A and B. Proving of handwriting. Proving of handwriting is provided in Indian Evidence Act, and its right option is both option D, which is both A and B. And what A and B says, by the opinion of experts or by the evidence of a person who is acquainted with the handwriting. Question number 59. Section 26 of Indian Evidence Act provides, or Section 59, question number 59. Section 26 of Indian Evidence Act provides, which was the previous proving of, okay. Section 50, question 59. Section 26 of Indian Evidence Act provides, option A, no confession made by a person in police custody is admissible. Option B, confession made by a person in police custody is admissible. Option C, confession made in the immediate presence of a magistrate is admissible. Option D, both A and C. Its right option is option D, which is A and C both. No confession made by a person in police custody is admissible, as well as confession made in the immediate presence of a magistrate is admissible, which is mentioned in Section 26 of Indian Evidence Act. Question number 60. The term evidence means and includes. The term evidence means and includes, option A, oral evidence. Option B, documentary evidence. Option C, electronic records produced for the inspection of the court. Option D, all of the above. Its right option is option D, which is all of the above. So oral evidence, as well as documentary evidence, as well as electronic records. Question number 61. Which is the authority that determines the language of the court other than High Court within a given state under Section 271 of CRPC? Which is the authority that determines the language of the court other than High Court given in a other than High Court given other than High Court within a given state under Section 271 of CRPC? Option A, state government. Option B, central government. Option C, Supreme Court of India. Option D, both A and B. Its right option is option A, which is state government. So, the state government can basically determine the language of the court under Section 271 of CRPC. Question number 62. A degree can be, option A, final. Option B, preliminary. Option C, only preliminary, not final. Option D, either preliminary or final. Its right option is option D, which is either preliminary or final. A degree can be either preliminary or final. Question number 63. Foreign judgment is defined in CPC. Option A, under section 2, subsection 6 of CPC. under section 2 subsection 7 of CPC, under section 2 subsection 8 of CPC, or option D, none of the above. Its right option is option A, which is under section 2 subsection C of CPC. Foreign judgment has been defined under section 2 subsection 6 of CPC. Question number 64. The minimum number of persons required to incorporate a public company is option A 5, option B 10, option C 7, option D 2. Its right option is option C, which is 7. So minimum 7 number of persons required to incorporate a public company. Question number 65 says a private company can commence business as soon as it receives option A certification of incorporation, option B letter of intent, option C occupation certificate, option D none of the above. Its right option is option A certificate of incorporation. Okay, so the private company can commence business as soon as it receives certification of incorporation. Question number 66. Which of the following is not an essential of a contract of guarantee? Contract of guarantee. Not essential. Option A. Concurrence of three parties. Option B. Sureties distinct promise to be answerable. Option C. Liabilities to be legally enforceable. Option D. Existence of only one contract. Its right option is option D, which is existence of only one contract. So existence of only one contract is not an essential of in basically contract of guarantee. Question number 67. The term agent is defined in Indian Contract Act under section. The term agent is defined in Indian Contract Act under section. Option we have 180 of 180 of the ICA, 181 of the ICA, 182 or 183. Its right option is option C 182 of the ICA, Indian that is Indian Contract Act. The term agent has been defined in section 182. The term agent has been defined. Question number 68. What is the maximum number of partners in banking business? Option we have 8, 10, 12, 16. Its right option is option B, which is 10. So at least maximum 10 members or 10 partners can be 10 person can become the partners in banking business. Question number 69. A person who gives the guarantee is called option A bailee, option B creditor, option C debtor, option C surety. Its right option is option D surety. Question number 70. Which is not a right of an unpaid seller against the goods? Question number 70. Which is not a right of an unpaid seller? Which is not a right of an unpaid seller? Means ये right नहीं होगा. So which is not a right of an unpaid seller against the good? Option A line, option B stoppage in transit, option C right of resale, option D to a certain price. Its right option is option D to a certain price. Question number 71. Section 36 to 42 of Specific Relief Act provides Option A, injunctions. Option B, court's discretion on specific performance. Option C, cancellation of instruments. Option D, none of the above. Its right option is option A, which is injunction. So section 36 242 of a specific relief act provides injunction, deals with basically injunction. Question number 72. Which of the following is not of civil nature? Which of the following is not of civil nature? Option A, right to take out procession. Option B, right to worship in a temple. Option 2, right to caste and religion. Option D, all of the above. Its right option is option C, which is right to caste and religion. Question number 73. In a suit where the doctrine of res judicata applies, option A, the suit is liable to be dismissed. Option B, the suit is liable to be stayed. Option C, both A and B. Option D, none of the above. Its right option is option A, which is the suit is liable to be dismissed. Question number 74. Under section 16 of CPC, a suit relating to immovable property can be filed in a court whose local jurisdiction is. Under section 16 of CPC, a suit relating to immovable property can be filed in a court whose local jurisdiction is. Option A, where the property is situated. Option B, where the defendant voluntarily resides or carries on business. Option C, both A and B. Option D, none of the above. Its right option is option A, which is where the property is situated. Question number 75. Pleading means option A, plain and written statement. Option B, plain only. Option C, written statement. Option D, oral statement by the pleader. Its right option is option A, which is plain and written statement. So pleading means plain and written statement. Question number 76. On failure to file a written statement, under Order 8 Rule 10, under Order 8 Rule 10 of CPC, the court may option A, pass any other order. Option B, order for striking of the decree. Option C, may pronounce the judgment at once. Option D, any of the above. So, question 76 says on failure to file a written statement under Order 8, Rule 10 of CPC, the court may option A, pass any other order. Option B, order for striking of the decree. Option C, may pronounce the judgment at once. Option D, any of the above. Its right option is option D, any of the above. So the court may pass any other order or order for striking of the decree or may pronounce the judgment at once. Question number 77. What is meant by homicide? What is meant by homicide? Option A, suicide by human being not at home. Option B, suicide at home. Option C, killing of a human being by another human being. Option D, killing of human being by animal. Its right option is option C, which is killing of a human being by another human being. That will be called, and that is basically meant homicide. Homicide. Question number 78. Adulteration of food or drink is punishable offense. Option A, under section 274 to 276 of IPC. Option B, under section 277 to 278 of IPC. Option C, under section 272 to 273 of IPC. Option D, none of the above. Its right option is option C, which is under section 272 to 273 of IPC. Question number 79. Maximum punishment for waging a war against the government of India under IPC is option A, Rigorous imprisonment up to 5 years. Option B, rigorous imprisonment up to 10 years. Option C, rigorous imprisonment for lifetime. Option D, death sentence. Its right option is option D, which is death sentence. So the maximum punishment for waging a war against the government of India under IPC is can be given as a death sentence up till the death sentence. Question number 80. We have 20 more questions, and the question number 80. Let's see question number 80. Offences relating to elections are option A, contained in the IPC as originally enacted, contained in the IPC as originally enacted. Option B, are introduced in the IPC by a subsequent amendment. Option C, are not covered by IPC. Option D, none of the above. Its right option is option B, which is are introduced in the IPC by a subsequent amendment. Question number 81. Rupa Bajaj versus KPS Gill. Rupa Bajaj versus KPL Gill is a famous case which the Supreme Court decided on. Option A, wrongful restraint. Option B, wrongful confinement. Option C, outrage the modesty of a woman. Option D, maintenance to the divorced woman. Its right option is option C, which is outrage the modesty of a woman. So the Rupa Bajaj versus KPS Gill is a famous case which the Supreme Court decided on outrage the modesty of a woman. Question number 82. Under the Hindu Adoptions and Maintenance Act, the person who is taken in adoption. Question number 82. Under the Hindu Adoptions and Maintenance Act, the person who is taken in adoption. Option A, must be a Hindu only. Option B, a Hindu or Jew. Option C, maybe Hindu or Christian. Option D, none of the above. Its right option is option A, must be a Hindu only. So under the Hindu Adoptions and Maintenance Act, the person who is taken in adoption must be a Hindu only. Question number 83. Polygamy was permitted for Hindus before the year 1956. Option A, 1956. Option B, 1954. Option C, 1955. Option D, 1978. Its right option is option C, 1955. So polygamy was permitted for Hindus before year 1955. Question number 84. Mohan gets married to his sister's daughter Kirti. Option A, the marriage is valid if the custom allows it. Option B, marriage is void. Option C, the marriage is valid only if the court approves it. Option D, the marriage is valid only if the panchayat permits. Its right option is option A, the marriage is valid if the custom allows it. Question number 85. Within the purview of Water Act, within the purview of Water Act, the meaning of stream is defined as. Option A, includes a river but not a water course. Option B, includes a water course but not a river. Option C, includes river and water course but not subterranean subterranean waters. Option D, includes a river, a course, and what is this? Subterranean river. And its right answer is option D, which is The Water Act, within the purview of Water Act, the meaning of stream and the meaning of a stream includes a river, a watercourse, and subterranean river. Question number 86, Section 2, Clause 1 or Subsection 1, JBZB of the Trademark Act 1999 defines the meaning of option A license, option B trademark, option C registration, option D cancellation. Its right option is option B, which is trademark. I am repeating the question once again. Section 2, subsection 1 of ZB of the Trademark Act 1999 defines the meaning of trademark. Question number 87. Outraging the modesty of a woman is punishable under IPC. Option A, Section 376A, 376B, 354, 498. Its right option is option C, which is Section 354. Question number 88. Section 463 of Indian Penal Code deals with the crime of option A, housebreaking, option D, dishonest misappropriation of property, option C, forgery, option D, forgery with cheating. Its right option is option C, which is forgery. So section 463 of Indian Penal Code deals with the crime of forgery. Section 463 deals with forgery. 463 463 of IPC deals with forgery. Question number 89. Criminal intimidation is explained in IPC under option A, section 503 to 506, option B, section 509 to 516, option C, 319 to 329, option D, none of the above. Its right option is option A, which is section 503 to 506. Question number 90. Under section 59 to 60 of Indian Evidence Act, under section 59 to 60 of Indian Evidence Act, the oral statement means option A, all statements made before the court by the witness, option B, all statement made before the police by the accused, option C, all statement of facts which is a witness heard to say, all statements of fact which a witness heard to say, which a witness heard to say, option D, all of the above. Under section 59 to 60 of Indian Evidence Act, the oral statement means all statement made before the court by the witness, all statement made before the police by the accused, option C, all statement of facts which a witness heard to say, option D, all of the above. Its right option is option A, all statements made before the court by the witness. Section 59 to 60 of Indian Evidence Act, the oral statement means all statements made before the court by the witness. Question number 91. Under the Evidence Act, court includes option A, all judges, option B, all magistrates, option C, all arbitrators, option D, which is option A and B both, which is all judges as well as all magistrate. Its right option is option D, which is all judges and all magistrate. Question number 92. Admissibility of contents of electronic records may be proved in accordance with the provisions of may be proved in accordance with the provisions of option A under section 61 of Indian Evidence Act, option B under section 65 of Indian Evidence Act, option C under section 65B of Indian Evidence Act, option D none of the above. Its right option is option C, which is under section 65B of Indian Evidence Act. So, admissibility of content of electronic record may be proved in accordance with the provision of under section 65B of Indian Evidence Act. Question number 93. Which is not a public record? Which is not a public record as per the provision of Indian Evidence Act? Which is not a public record? Which is not a public record as per the provisions of Indian Evidence Act? Option A. Documents forming the acts or records of the sovereign authority. Option B. Documents forming the acts or records of official bodies, tribunals. Option C. Documents and correspondence from advocate and notary office. Option D. Documents and circulars from University of Delhi. Its right option is option C, which is documents and correspondence from advocate and notary office. Which is not a public record as per the provisions of Indian Evidence Act. Documents and correspondence from advocate and notary office. Question number 94. Section 67 of Motor Vehicle Act 1988 provides Section 67 of Motor Vehicle Act 1988 provides option A possession of driving license while driving, option B possession of insurance certificate and a PUC certificate, that is somewhere related with pollution, and PUC certificate in the vehicle. Option C, revoking driving license if drunk driving is detected. Option D, state government's power to control the road transport. Its right option is option D, which is state government's power to control the road transport. So, Section 67 of Motor Vehicle Act 1988 deals with the power of the state government to control the road transport. Question number 95. The term tort is a option A Latin word, option B French word, option C English, option D Italian. Its right option is option B, which is French word. But as far as I have heard, the tort is a Latin word, but you have to confirm it because here I can see the right option is showing which is option B and saying it's French word. It may be error, by the way. It may be error. The right answer may be Latin, from Latin word, as far as we have learned in our colleges. Let me confirm. या इसका राइट ऑप्शन बी होगा, फ्रेंच वर्ड। बेसिकली इसका जो ओरिजिन है टॉट का, वो लैटिन से लिया गया, बट फ्रेंच बाद में फ्रेंच डिक्शनरी में इसको ऐड कर लिया गया था, तो फ्रेंच लॉ से जो टॉट का जो टर्म है वो लिया गया है। सो बी जो फ्रेंच वर्ड है, ये इसका राइट ऑप्शन है। एंड ये कंफ्यूज करने के लिए कि वेदर इट इज लैटिन एंड फ्रेंच, ये इसमें मेंशन किया गया था। So the right option is French word. The term tort is a French word which originates from Latin word, from Latin. Question number 96 in tort, what is vicarious liability? In question number 96 in tort, what is vicarious liability? Option A, a person is generally liable for his own wrongful act. Option B, a person is liable for the wrongful act done by other person. Option C, a person is liable for the wrongful act in his absence. Option D, none of the above. Its right option is option B, a person is liable for the wrongful act done by other person. Question number 97, under section 2 subsection 1 F of the Consumer Protection Act 1986, defect is meant by any fault, imperfection or shortcoming in dash in relation to the goods. Option we have quality and quantity. Option B, potency. Option C, purity or standard. Option D, all of the above. Its right option is option D, which is all of the above. So any fault in quality and quantity, potency and or purity or standard in relation to the goods. Question number 98. Which of the following falls under the categories of act of God? Option B have storm and cyclone. Option B, extraordinary rainfall or flood. Option C, lightning and thunder. Option D, all of the above. Its right option is option D, which is all of the above. So the act of God will include storm and cyclone, extraordinary rainfall or flood. Option C, lightning and thunder. Question number 99. Income Tax Act was enacted in option we have in 1951, in 1961, in 1971. Option D, none of the above. Its right option is option B, which is 1961. Question number 100, which is last question. Income is defined under section 24 of the Income Tax Act. So income is defined under section 24 of the Income Tax Act. Option we have profits and gains. Option B, dividend. Option C, voluntary contribution received by a trust for charitable purpose. Option D, all of the above. Its right option is option D, all of the above, which is profit and gain as well as dividend as well as voluntary contribution received by a trust for charitable purpose. So income is defined under section 24 of the Income Tax Act as profit and gains or dividend or voluntary contribution received by a trust for charitable purpose. That's it. And here we just finished the previous question paper of AIBE 11. This was the part second. Okay. In part one, we just finished we just solved the question from 1 to 35, and in part two from 36 to 100. So that's it.